In the bail application of the 6 men accused of killing Gauteng Health Department official Babita Deokaran. Let's take you live to that.
With about 30,000 rands per month, which includes his contribution for living at her home. The applicant has no previous convictions. There's no pending matters against him other than the one before court. He believes that in his opposition to his release on bail, the state contends that the evidence that incriminates him in the commission of the offense is that of 2 photographs of the residential complex where the deceased resided. He saved in his mobile phone, and that the deceased motor vehicle appeared in one of these photos. Further, that after his arrest, he confessed. Applicant respectfully submits that the evidence that links him to the commission of the offense or offenses preferred against him is barely circumstantial. Applicant states that he is innocent of the charges preferred against him. He has no knowledge of and was not involved in the murder of Ms. Babita Deokaran, nor any conspiracy to murder. In regard to the photos on his mobile phone, which are as or ostensibly that of the complex where the deceased resided, applicant confirms that as a bold driver, the history of his rides will confirm that he often works in the Johannesburg South area, including Mondio. At some point during his travels in the area, he had taken photos of various complexes, in that he was planning to rent a flat or townhouse in the area to take up such residence in a unit with a girlfriend. It may be that the 2 such photos are that of the deceased residence and that the deceased motor vehicle appears in one such photo. Applicant denies that the photos were taken for any nefarious purpose. Furthermore, at the time of taking such photos, he was not aware that the said motor vehicle belonged to the deceased. Applicant states that it is correct that he was arrested on the night of the 26th of August 2021 whilst driving his Volkswagen Polo with registration numbers and letters HV49KJGP. He was with a friend, Onke. They were at Shell filling station, filling in some petrol. Suddenly, an unmarked vehicle pulled up on the forecourt of the filling station, blocking his path, and around 3 occupants jumped out, pointing guns at Onke, and he was ordered, together with Onke, to climb out of the vehicle. He believed that they were about to be robbed. He tried to run, but a second vehicle blocked his path. He was apprehended. Onke and himself were bundled into separate vehicles and taken to Tarfontein Racecourse, where each of them were removed from separate vehicles and made to lie face down on the ground, both handcuffed behind their backs. At that point, given the accusations held at him by their abductors, he realized that they were in fact police officers. And later, some police officers in uniform arrived. They were being accused of having killed someone. A policeman who was principally involved in his interrogation consistently threatened that he was going to kill him, pointing his firearm at him. At some point, he was threatened that he was going to be taken to a dam to swim. Though he was threatened and manhandled, at that stage, he was not really assaulted. He was then taken to a home in Victoria Street, Rosettenville, where some of other suspects, who are his co-applicants, were arrested. There again, he was interrogated and accused of being involved in the murder of an Indian woman earlier that week. The interrogation by the three officers also included assaults. He was accused of being the mastermind of what appeared to be a contract killing. The allegation being that they were paid a sum of 400,000 rands. He was told that his accomplices have confessed and that he should also confess and reveal where the money was, where the guns were, and who hired him. Later, he was interrogated by the investigating officer, Captain Chauke himself, who threatened him that he'll be assaulted and killed if he does not confess. Applicant then falsely confessed to his involvement, and Captain Chauke proceeded to read from some documents what the applicant and others had purportedly done. He simply confirmed it to be correct. Applicant finally consulted with his attorney, Mr. Sally, during the afternoon of Saturday, the 28th of August 2021. He conveyed to Mr. Sally that he had been assaulted, threatened, etc. His attorney informed him of his rights, including also a right to remain silent. In the circumstances, applicant humbly submit that the state can hardly be said to have a strong case against him. It can hardly be said that there is a disposition on his part to commit offences referred to in Schedule 1. There's also no evidence that the applicant had previously committed an offence referred to in Schedule 1. Applicant submit that his emotional and occupational ties are in Gauteng. He was born and bred in this country. His family is historically tied to KwaZulu-Natal rural community. He has no passport to leave the country. There are no prospects of him leaving the country. He will not threaten or intimidate witnesses. Applicant states that his release on bail will not undermine or jeopardize the public confidence in the criminal justice system. In conclusion, applicant submits that to allay any fears that the state may have, the court may impose suitable bail conditions. He can raise an amount of 10,000 rands for bail, and applicant requests to be released on bail. Applicant number 6, Sipakanyiswa Dladla, stated the following in his affidavit: that he is a South African, resides at number 32 Victoria Street, Rosettenville, Johannesburg. At the time of his arrest, he had lived at the said residence for about 5 months, and he previously lived at number 13 Aero Street, Captain Park, where he resided for 2 years. He's 25 years old, was born in Winnen, KwaZulu-Natal. He spent most of his teenage years in his village in Hlawe district, where there are no streets, no street numbers. He's unmarried. His mother is a pensioner. His father is deceased. He's born and bred in South Africa, has no passport, and has not applied for one. He has never left the Republic of South Africa. He has no friends, no relatives who live beyond our country's borders. Applicant is a taxi patroller with Captain Park Taxi Association, earns approximately 3,200 rands per month, and from his taxi earns approximately 10,000 rands per month. He does not have children, but supports his mother to the tune of 3,000 rands per month. He has no previous criminal convictions, no outstanding matters against him. He was never arrested before. The state, in its opposition, has produced an application for a warrant of his arrest authorized on the 2nd of September 2021 after his arrest on this matter. Applicant denies knowledge or involvement in such matter. Applicant submits that the consideration of the allegations on the part of the state that incriminate him in the commission of the offences being preferred against him is based on a single allegation that he made a bond out and confession in respect of his involvement in the murder of the deceased. He is innocent of the charges being preferred against him. He has no knowledge and was not involved in the murder of Ms. Babita Deokaran, nor any conspiracy to commit such murder. It is common cause that he was arrested whilst at his residence at number 32 Victoria Street, Rosettenville, Johannesburg, at the same time as several of his co-applicants were also arrested. Applicant was assaulted. There were about 20 police officers. He was accused of being involved in the recent murder of an Indian woman at Mondio, which accusation he persistently denied. The interrogation and assault continued at Johannesburg Central Police Station. He was assaulted, threatened that he would be killed. He was terrified that he would be killed, and eventually, to stop the beatings, he said that he would confess. He was informed that his confession would be taken by a senior police officer. An hour or so after his warning statement, he was taken to a different building in the Johannesburg CBD, where he met a senior officer who proceeded to take his formal confession, and later pointing outs were done. At some point, he asked if he could have a lawyer, but was told that he would have a lawyer later. Applicant states that the confession and pointing out he did were done as a result of him being forced and were obtained under duress. Applicant submits that the state can hardly be said to have a strong case against him. He has no previous convictions. He submits that his emotional and occupational ties are both in Gauteng and KwaZulu-Natal. His taxi business is also in Gauteng. He was born and bred in this country. His family is historically and presently tied to the KwaZulu-Natal rural community. He has no passport. There is no prospects of him leaving the country. He will not threaten or intimidate the witnesses. His release will not undermine or jeopardize the public confidence in the criminal justice system. If he remains incarcerated, it is clear that he will not only suffer considerable financial loss, but preparing for trial will clearly irreparably prejudice him in the successful prosecution of his defense. It's not a flight risk. Applicant states that the prison conditions for awaiting trial inmates at Johannesburg prison are horrendous and in fact constitute a gross violation of inmates' constitutional rights. In conclusion, applicant requests the court to release him on bail with suitable conditions and is able to raise an amount of 10,000 rands as bail. The attorney of the applicant, Mr. Sali, made a confirmatory affidavit wherein he states that he's an adult male attorney, duly admitted and practicing as such, and that he's a senior partner at Sali and Ishmael Incorporated in Johannesburg. He confirms that the afternoon of the Friday, the 29th of August 2021 at approximately 3 to 4 p.m., he received instructions to urgently represent 7 applicants, including Onke, who had been arrested earlier that day or the night before on charges relating to the recent murder, namely on the 23rd of August 2021 of the Chief Director of Financial Accounting in the Department of Health, and which killing had received widespread media attention. Having learned that the applicants or his clients had been arrested in the Rosettenville areas and that the offense had been committed within the Mondio districts, he set about, together with his staff, including the assistant attorney employed at their firm, that is T.N. Peters, and his secretary, Adrian Tuan, to call various police stations in the area of Mondia and Boisens to ascertain whether the applicants were detained at police stations in such areas. Despite numerous calls, including to Johannesburg Central Police Station, they could not trace the whereabouts of the applicants. Several officers were phoned in trying to locate the applicants with no success. Mr. Sali also states that to assist him in the tracing of the applicants, he briefed Advocate Wilkins, who, from periodical reports, was equally unsuccessful in tracing the whereabouts of the clients. By the morning of Saturday, the 30th August 2021, he had not been able to trace the applicants. And this prompted him to discuss with Advocate Wilkins the possibility of bringing an urgent application against the Special Unit and the Minister of Police to force them to disclose the whereabouts of the applicants, and of course, to allow him access to his clients. The same morning of the 30th of August 2021, he finally received information from a source that 7 clients were being detained at Johannesburg Central Police Station. He eventually decided to attend personally at Johannesburg Central Police Station, where he, after a lot of challenges and frustrations, eventually located his clients at the police station. Each of the clients, excluding Onke, complained that they had been assaulted. Mr. Sali also confirms and corroborates the contentions and assertions made by the applicants in the affidavits in support of their release on bail, insofar as same relates to him. More particularly, the assertions dealing with the challenges faced in proper legal visits at Johannesburg prison. Mr. Shafiq Sali, applicant's legal representative, made a supplementary affidavit and stated the following: that in proper fulfillment of his mandate and duty to the applicants, he had considered obtaining an appropriate affidavit from our former Minister of Health, Zweli Mkhize, of course, with the prior consent of the state. It is common cause that in response to their request to engage with Zweli Mkhize's attorneys, the state placed on record during bail proceedings on Friday, the 5th of November 2021, that Zweli Mkhize was considered a potential state witness or suspect in the investigations. Consequently, they are unable to solicit any comment from Zweli Mkhize regarding his incrimination by the first applicant in his confession that now forms part of the record of the bail proceedings. However, Mr. Sali believes that it is in the interest of justice and this bail court be seized with all the relevant information and facts of the matter, that it be disclosed that Zweli Mkhize has widely circulated media reports, in fact, responded to the said allegations that have been made against him in the said confession. Mr. Sali believes it's salient to record one such report by the Daily Maverick, wherein inter alia it is stated, a statement from Mkhize released on Wednesday said that it was with shock and sadness that he learned that his name had been dragged into the case. The men arrested in connection with Deokaran's murder. Mkhize would like to take this opportunity to assure the Deokaran family and all South Africans who are still reeling from the trauma of this scaleless crime that he had absolutely nothing to do with it, nor the alleged procurement irregularities which are believed to have driven it. The statement reads, it should be remembered that these alleged procurements irregularities took place at the provincial level, far away from the national sphere of government where he was deployed as the National Minister of Health. Respectfully, the unequivocal denial by Zweli Mkhize of the contents of the confession by the first applicant in connection with Zweli Mkhize's involvement in the crime, together with at least explanation as to the improbability of his connection with the offense, offers further basis for a finding, even at this early stage, and moreover, at the hearing of this bail application, that the confession of the first applicant, and at least in this material respect, is palpably false. This court will deal with this aspect at the later stage. The state, through the affidavit of one Percy Chauke, responded as follows. That is an adult male South African employed by the South African Police Service, holding the rank of a captain, stationed at Central Johannesburg Central Serious Organized Crime Unit. He is the lead investigating officer of Mundia Cas 369 of 8 of 2021, which relates to the current application before court. The investigating officer states the following: further, that applicant number 1, Phakamani Hadebe, was arrested on the 26th of August 2021 at approximately 1940 hours in Rosettenville whilst driving and being the only occupant of a Volkswagen Polo with registration numbers CV 82BJ-GP, which vehicle was used in the planning and execution of the murder. Phakamani Hadebe, shortly after his arrest, made a confession in respect of the events on the 23rd of August 2021, as well as the days leading up to the incident, to the Justice of Peace, a captain in the SAPS, which included details of all his co-accused, as well as the identity of the persons who ordered the murder of the deceased. Phakamani Hadebe provided a residential address of number 106 Sheffield Street, Rosettenville. Prior to residing in Rosettenville for a month, he comes from KwaZulu-Natal from an unknown address. A J50 warrant of arrest has been authorized for Phakamani Hadebe in respect of escort CAS 5705 of 2019 relating to charges of murder and robbery. Applicant number 2, Zita Hadebe. On the evening of the 26th of August 2021, members of the SAPS acting on the information they have received attended the residential premises of number 32 Victoria Street in Rosettenville. At this residential address, they found the third, fourth, and sixth applicants inside the room. The third applicant was arrested inside the room, whilst the fourth and the sixth applicants ran into a bathroom where they were arrested. An unlicensed firearm was located at the premises, which, along with DNA samples taken from all the suspects or the applicants, is being subjected to DNA analysis to ascertain who all possessed the firearm. On the afternoon of the 23rd of August 2021, in Captain Park, Zita Hadebe, along with the suspect yet to be arrested, was seen in possession of a white BMW with the same distinctive features that was seen following the deceased vehicle, as seen fleeing the vicinity of the scene of the offense. Zita Hadebe, together with Lovu, Mbele, and Ladla, gave their residential addresses as number 32 Victoria Street, Rosettenville. The address verified with one Mrs. Unke, who did indicate that all four applicants have resided at the premises for only 3 weeks prior to their arrest. Zita Hadebe, prior to the 3 weeks resident in Rosettenville, comes from KwaZulu-Natal from an unknown address. Zita Hadebe is also sought by the police in respect of Linden, CAS 227 of 6/2015, and Captain Park, CAS 366 of 6/2015. Applicant number 3, Phindandlovu, was arrested at number 32 Victoria Street, Rosettenville on the 26th of August 2021. After his arrest, Phindandlovu made a pointing out to Lieutenant Colonel of the SAPS, wherein he admitted his involvement in the murder. The residential address he provided, number 32 Victoria Street, was occupied by him and others for 3 weeks prior to their arrest. Before the 3 weeks period, he came from KwaZulu-Natal from an unknown address. A bench warrant of arrest was issued for Phindandlovu, 15th of June 2021 at the Alexander Regional Court for failure to appear before court in respect of Regional Court 310 of 2021, which relates to a charge of possession of an unlicensed firearm. Applicant 4, Sanele Mbele, was arrested in the bathroom at 32 Victoria Street, Rosettenville, on the evening of the 26th of August 2021. He later made a pointing out and confession regarding his involvement in the murder. He provided his residential address as 32 Victoria Road, Rosettenville, a residential address he occupied for 3 weeks prior to his arrest. Stanley Mbele comes from KwaZulu-Natal from an unknown address. Applicant number 5, Siphiwe Mazibuko, was arrested on the 26th of August 2021 at approximately 20:45 hours whilst driving his Volkswagen Polo with registration numbers HV49JKGP. It has been established that the photo of the residential complex that the deceased resided at was saved on his mobile phone. Upon his arrest, and having been warned of his rights, Siphiwe Mazibuko confessed of his involvement in the offense. However, at a later stage, when formally booked out to have his statement reduced to writing, he stated that he had consulted an attorney who told him not to say anything further. Applicant number 6, Siphakanyiso Dladla, was arrested on the evening of the 26th of August 2021 at number 32 Victoria Street, Rosettenville. After his arrest, Siphakanyiso Dladla made a point out and confessed in respect of his involvement in the murder of the deceased. A J50 warrant of arrest was issued for Siphakanyiso Dladla in respect of a murder and robbery that occurred on the 11th of May 2019 in Estcourt. He gave his address as number 23 Victoria Street, Rosettenville, an address he occupied for 3 weeks prior to his arrest. He comes from KwaZulu-Natal from an unknown address. Applicants 1 to 6, legal representative address the court as follows: that the state intends to prosecute all the applicants with the offenses contained in Schedule 6 of Act 51 of 1977. It follows that the provisions of Section 60, Sub 11, Subsection A of the Act are applicable. It is tried that the applicants carry the burden of satisfying the court on the balance of probabilities that exceptional circumstances exist which in the interest of justice permit their release on bail. The court is asked to take into account the following general principles applicable to bail applications in mind: the right to legal representation being the backbone of our legal system for a very long time. That in Brink versus Commissioner of Police, 1960, Volume 3, SA, page 65, a Transvaal decision, at paragraph 67B to C and 68A to 69H. The court stated that it is a fundamental right of every South African citizen, upon apprehension or arrest, to obtain legal advice and to consult with his or her legal advisors. The right has now been constitutionally entrenched in terms of Section 35(2) sub B of the Constitution of the Republic. Everyone who is detained, including a sentenced prisoner, has the right to choose and to consult with a legal practitioner and to be informed of his rights promptly. An accused, in the absence of a conviction by the court of law, is constitutionally presumed to be innocent. In S versus Atchison, 1991, Volume 2, SA 805, it's a Namibian court decision. at page 822, A to B, Mohammed J. emphasized that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused unless this is likely to prejudice the ends of justice. In State versus Jonas, 1998-2, South African Criminal Report 677 SEC, Horan J. inter alia, remarked as follows: it could not have been the intention of the legislature when it amended the Act by introducing Section 60 sub 11A to legitimize the random incarceration of persons who are suspected of having committed Schedule 6 offenses. Such persons must, after all, be regarded as innocent until proven guilty in a court of law. The introduction of Section 60 sub 11A was intended to make the obtaining of bail by accused persons who are charged with certain serious offenses more difficult, but not impossible. The applicants submit that, notwithstanding uncomplicated dictionary meaning of exceptional circumstances, it has proved to be an elusive concept. In the main, the applicant's legal representative, as per the heads of argument, submit that the state cannot link the applicants to the charges preferred against them. Only through forced confessions and point outs is the state alleging that the applicants are linked to the offense. That the applicant's right to legal representation and access thereto was infringed deliberately by the police officers, inclusive of the investigating officer. That this bail court has to pronounce that the confessions and point outs obtained by force or assault to the applicants will at trial not be admissible. Furthermore, that applicant number one cannot be linked to the firearm, was not found in possession. This weakens the state's case. Exceptional circumstances exist. Applicant number two was seen driving the BMW motor vehicle. The BMW motor vehicle was not found. This does not take the state case further. Second applicant never took the police to where the offense was committed, the scene where the deceased was shot. Nothing was said by the applicant during the point out. Confession was made by a co-accused. There's no evidence against the second applicant. The state case is non-existent against him. For applicant number three, the state relies on inadmissible evidence. Investigating team did not respect applicant number three's right to access or right to legal representation. Applicant taken to do point outs by officers knowing that Mr. Sali, his legal representative, is available. State case is non-existent against accused or applicant number three. In respect of applicant number four, identification given by the police officer gives very little information. The BMW motor vehicle was never found. It seems that it cannot be found. There's no strong case against applicant number four. Applicant requested the police to contact family, but never given an opportunity. Was assaulted, broken tooth, cut on the lip, and was bleeding. The investigating officer, Mr. Chauke, denied legal access to applicant number 4. State case is extremely weak against him. In respect of number 5, he's linked through photos found in his phone. Photos were taken because he was considering to buy a townhouse in the area. Confession against applicant number 5 is inadmissible. State case is weak against him. In respect of applicant number 6, applicant number 6 was assaulted, tortured by the police. They point out confession made by him is inadmissible. The state case is also weak against applicant number 6. In conclusion, applicants state that they've discharged the onus on them. They've proven that exceptional circumstances exist which in the interest of justice permit their release on bail, and consequently request that the court should release all of them on bail. The state addressed the court on the following: the strength of the state case or the lack thereof, and prior addressing the attack by the applicants on the strength of the state case, the state respectfully submitted that the following principles should be kept in mind. Section 60, sub 11b(c) of the Criminal Procedure Act provides the record of bail proceedings, excluding the information in paragraph A, shall form part of the record of the trial of the accused following upon such bail proceedings, provided that if the accused elects to testify during the course of the bail proceeding, the court must inform him or her of the fact that anything he or she says may be used against him or her at his or a trial, and such evidence becomes admissible in any subsequent proceedings. Applicants, as indicated, submitted affidavits as alternative to viva voce evidence. The remarks of Homu J. in S versus Agliotti, 2012-1, SACR 559, GSJ, at paragraph 39, are worth repeating. It is my considered view that even where an accused and an applicant in the bail hearing concerning Schedule 6 offences intends to use an affidavit, it is peremptory duty of the court, right at the beginning of the proceeding, to warn him fully and comprehensively of the provisions of Section 60, sub 11b(c), that would allow the applicant or an accused to make an informed choice before he decides to testify viva voce or making use of an affidavit. It does not make sense to me to want to utilize evidence obtained through both oral testimony and affidavit, but accept the owner of such evidence to be warned only when he testified orally. As stated before, both oral evidence and affidavit are evidence that may be used in subsequent trial. As such, the requisite warning should be issued by the court to the accused before he or she elects to orally to use an affidavit. If he has been properly warned, then those bail proceedings should be admissible in his subsequent trial. The applicants were fully and comprehensively warned by the Honourable Court at the commencement of their application, and all evidence presented by them during their application for release will be admissible against them at subsequent trial. The applicants all raised similar issues regarding the admissibility of the separate statement due to non-compliance with the relevant sections of the Criminal Procedure Act, as well as alleged refusal to consult a legal representative. It is, however, necessary to highlight certain aspects of each applicant's version separately. The first applicant's affidavit, as per paragraph 42, contained at page 122 of the bundle, reads: I then proceeded to narrate what I expected from my torturers wanted of me, some of the content I had gleaned from the lengthy interrogation of me. The second applicant states, as per paragraph 25 of the affidavit contained at page 182 of the bundle, I later proceeded to make a random pointing out to some police officer and was then also driven to one or two spots which appeared to be of significance in the investigations. The fourth applicant states, as paragraph 36 of his affidavit contained at page 284 of the bundle, I had simply taken the officer to Mondio, whereafter, given my inability to precisely show where the shooting occurred, I don't manage to glean this from the accusations leveled against me during my interrogation. I was taken to a place by the officer where I gathered the shooting occurred. The sixth applicant states in paragraph 31, 32 of his affidavit contained page 375 of the bundle. I was taken by the captain to a complex where photos were taken of me. After the road trip, I proceeded to then again convey to Captain Madibo much of the information I had gleaned from the earlier interrogation. Although further and full argument will be made in relevant time of trial, it is at this stage suffice to say first, second, fourth, and sixth applicants on their own versions are not the authors of their confessions or admissions made by the conduct. As such, the issues related to their respective statements deal with credibility and not admissibility thereof. Even if the trial court rules that the issues raised by the applicants amount to a question of admissibility by way of trial within a trial, the state would be entitled to confront the applicants with the content thereof during a trial within a trial. The remarks by Boschers J. in Esses versus Marke, 2001-2 SACR 28W at 289J 290B highlights as much. State versus Gaba, 1985 4 SA 734A. It was held that it was irregular for a trial judge to ask a witness to read out the contents of a confession during a trial within a trial before a ruling had been made on its admissibility or inadmissibility. An exception is made to the general rule where an accused alleges that the content of the confession or an admission were told to him by the police and were not within the accused's own knowledge. In contrast, the third applicant states in paragraph 32 of his affidavit contained at page 280 of the bundle, under these circumstances, I then proceeded to do the pointing out. It is clear that although the admissibility thereof may have to be determined by the trial court, the author of the admissions by conduct was the third applicant, and the information contained therein was not provided to him by the police. This on its own proves a prima facie case against the third applicant. As per the supplementary affidavit of Captain Chauke, the relevant witnesses, including Captain Chauke, dispute the allegations made against them by the applicants. It is further respectfully submitted that the comments of Herr J.A. in S versus Matibula 2010-1 SACR 55 Supreme Court of Appeal at paragraph 12 are significant. In order successfully to challenge the merits of such a case in bail proceedings, an applicant needs further to prove, or he must prove on a balance of probability that he will be acquitted of the charges. But the state is not obliged to show his hand in advance, at least not before the time when contents of the docket must be made available to the defense. Nor is an attack on the prosecution's case at all necessary to discharge the onus. The applicant who chooses to follow that route must make his own way and not expect to have it cleared before him. Thus, it has been held that in an application, until an applicant has set up a prima facie case of the prosecution, failing, there's no call on the state to rebut his evidence to that effect. It is respectfully submitted that the mere fact that the applicant's intent challenging the admissibility of this statement does not meet the threshold set in State versus Matibula above. The issue of admissibility and or credibility of statements will be decided by the trial court, having considered the credibility and reliability of the witnesses in the matter, as well as the probabilities and improbabilities in the evidence. Such evidence is not before this honorable court, and a determination of admissibility is not currently possible, nor is it required. The applicants have elected to present the confessions and admissions by conduct, established that the state factually has a prima facie case against them. Further, the state will at the time of the trial argue that the first and the sixth applicants have, to their benefit, directly referred to their confessions. The first and the sixth applicants' confession, regardless of the aforementioned issues related to credibility versus admissibility thereof, and therefore admissible against them in terms of Section 2173 of the Criminal Procedure Act. The affidavits of Captain Chauke highlights that there is additional circumstantial evidence creating a prima facie case against the applicants. It is proper for a court to convict an accused on circumstantial evidence, provided it has the necessary probative force to warrant conviction. This, as stated in S versus Nkuna, 2012, 1, South African Criminal Law Reports at 167B at 170A. The evaluation of circumstantial evidence must be guided by a test of reasonableness. The onus on the state is not that it must prove its case with absolute certainty or beyond any shadow of a doubt. All that is required is such evidence as to satisfy the court and prove its case beyond reasonable doubt. In respect of circumstantial evidence, the following requirements must be met. The inference sought to be drawn must be consistent with all proven facts. The proved facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. What is clear from the above is that a determination in respect of the circumstantial evidence will only be possible after the trial court has heard all the evidence. The applicants merely referring to the state case as barely circumstantial no way proves that the applicants will be acquitted of the charges. It is respectfully submitted that the applicants, in respect of their attacks on the confession, admissibility by conduct, and the circumstantial evidence, have failed to show on the balance of probabilities that they will be acquitted of the charges they face. It is therefore respectfully submitted that the applicant's attack on the state case does not provide them with the required exceptional circumstances. Insofar as the present conditions are concerned, should the applicants not be satisfied with the conditions, they find themselves in, they should have various legal remedies available to them, as stated in State versus Van Wyk 2005-1, SACR 41, SCA at 45H. In conclusion, it is ultimately respectfully submitted that the applicants have failed to show the presence of the required exceptional circumstances. The State, therefore, respectfully submitted that the application for the release of the applicants on bail pending finalization of their trial should be dismissed. As far as the applicable law is concerned, Section 35 of the Constitution of the Republic, that is Act 108 of 1996, on arrested, detained, and accused persons, Section 35(1) states, everyone who is arrested for allegedly committing an offense has the right, at his first court appearance, after being arrested, to be charged or to be informed of the reason for his detention, to continue or to be released. F, to be released from detention if the interests of justice permit, subject to reasonable conditions. Section 60(11) of the Act, that is Act 51 of 1977, that is the Criminal Procedure Act, states, notwithstanding any provisions of this Act, where an accused is charged with an offense referred to in A, that is Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permit his or her release. In State versus Matebula, 2010, 1 SACR 55 SCA, where the appellant was arrested on charges of murder and possession of arms and ammunition, since the main charge formed part of the category of the offences in Schedule 6 to the Criminal Procedure Act 51 of 1977, the appellant undertook the task of adducing evidence to satisfy the court that the exceptional circumstances existed which in the interest of justice permit his release on bail by way of an affidavit. It was held that the appellant relied upon affidavit evidence which was not open to test by cross-examination and therefore less persuasive. It was held further that to successfully challenge the merits of the state case in bail proceedings, the applicant must prove on a balance of probabilities that he will be acquitted of the charge. Until the applicant had set up a prima facie case, with the prosecution failing, there was no call on the state to rebut his evidence to that effect. That the appellant had not contributed anything to establish the existence of exceptional circumstances. Furthermore, that the parroting of the terms of Section 60 sub 4 did not establish any of the grounds without the addition of the facts that added weight to the appellant's ipse dixit. Resultantly, the appeal accordingly was dismissed. In reverting back to this application, the applicants, each of them, claim that they were assaulted, threatened, or tortured to make confessions and point out to certain things. It is submitted by the applicant's legal representative that it is permissible to refer to the confession and point out and argue why is that admissible at this stage. Reference being made to the matter of Mahlangu and another versus Minister of Police, 2020, Volume 2, SACR 136, the Supreme Court of Appeal decision, where it was held on probability had the plaintiffs in this matter applied for bail. The magistrate, hearing the bail application, just like a judge in the trial court, would have had no difficulty in concluding that the confession was inadmissible. However, this court wishes to state that there are sharp differences between Mahlangu's matter and the matter or the bail application this court is seized with. There's no common cause in this bail application that the applicants were assaulted, tortured, unlike in the Mahlangu matter, where there was common cause, or this was common cause. Therefore, this court is not going to make any finding that the confessions and pointing outs are inadmissible. The admissibility or not of the confessions and the pointing outs will be determined by the trial court. As to whether the applicants were denied their right to legal representation or access to their legal representative, this aspect is also in dispute and has a bearing on the admissibility or not of the confessions and pointing outs. Resultantly, this court is also not going to make any finding on this aspect, for it will be determined by the trial court. In his supplementary affidavit and on argument by the applicant's advocate, it was stated that the unequivocal denial by Zweli Mkhize of the contents of the confession by the first applicant relating to Zweli Mkhize's involvement in the crime, together with at least the explanation as to the improbability of his connection with the offense, affords further basis for a finding, even that at this early stage, and moreover, at the hearing of the bail application, that the confession of the first applicant, at least in this material respect, is palpably false. The advocate arguing furthermore that Zweli Mkhize's press statement, as per the Daily Maverick, as per Annexure SS1, should be given weight. This court wishes to state that the legal representatives of the applicants are misdirected on this aspect. Their argument cannot be upheld in that Zweli Mkhize's press statement was not made under oath. It is a mere press statement with no evidential weight, and therefore this court is not going to attach any weight to such press statement. Furthermore, the court is not going to make a finding that applicant's one's confession is false. Applicant 126 face serious offences. If convicted, they might be sent to prison for a very, very long time. This might necessitate the applicants not standing their trial if released on bail. All 6 applicants, either by confessions or point outs at this stage, are linked to the murder of Babita Deokaran until such time that the trial court makes a finding on the admissibility or not of such confessions and pointing outs. Applicant number 1, Pakamani Hadebe, was arrested on the 26th of August 2021 at approximately 1940 minutes in Rosettenville whilst driving and being the only occupant of a Volkswagen Polo with registration numbers CV H2BJGP, which vehicle was used in the planning and execution of the murder. Pakamani Hadebe, shortly after his arrest, made a confession in respect of the events of the 23rd of August 2021, as well as the days leading up to the incident, to the Justice of Peace, a captain in the South African Police Service, which included details of all his co-accused or applicants, as well as the identity of the persons who ordered the murder of the deceased. On the afternoon of the 23rd of August 2021, Captain Park, Zita Hadebe, along with a suspect yet to be arrested, was seen in possession of a white BMW with the same distinctive features that was seen following the deceased vehicle and seen fleeing the vicinity of the scene of the offense. Zita Hadebe, together with Ndlovu, Mbele, and Ladla, gave their residential addresses as 32 Victoria Street, Rosettenville. The address verified with one Mrs. Unke, who indicated that all 4 applicants have resided at the premises for only 3 weeks prior to their arrest. Zita Hadebe, prior to the 3 weeks, resident in Rosettenville, comes from KwaZulu-Natal from an unknown address. Zita Hadebe is also sought by the police in respect of Linden, CAS 227 of 6 of 2015, and Captain Park, CAS 336 of 6 of 2015. Applicant 3, Ndlovu, was arrested at number 32 Victoria Street, Rosettenville on the 26th of August 2021. After his address, Ndlovu made a pointing out to Lieutenant Colonel of the South African Police Service, wherein he admitted his involvement in the murder. The residential address provided, number 32 Victoria Street, was occupied by him and others for only 3 weeks prior to their arrest. Before the 3 weeks period, he came from KwaZulu-Natal from an unknown address. A bench warrant of arrest was issued for Ndlovu on the 15th of June 2021 at Alexandra Regional Court for failure to appear before court in respect of Regional Court 310/2021, which raised to the charge of possession of a licensed firearm. And not only did he not appear before court in this matter, and this court rejects his explanation as to failure to appear before court on those two occasions, in that it's unconvincing and appears to be false or untrue. Applicant number 4, Sanele Mbele, he was arrested in the bathroom at 32 Victoria Street, Rosettenville, on the evening of the 26th of August 2021. He later made a pointing out and confession regarding his involvement in the murder. He provided his residential address as 32 Victoria Road, Rosettenville, a residential address he occupied for 3 weeks prior to his arrest. Sanele Mbele comes from KwaZulu-Natal from an unknown address. Applicant number 5, Sipho Mazibuko, was arrested on the 26th of August 2021 at approximately 20:45 while driving his Volkswagen Polo with registration numbers HV49JKGP. It has been established that a photo of the residential complex that the deceased resided was saved in his mobile phone. Upon his arrest, and having been warned of his rights, Sipho Mazibuko confessed of his involvement in the offense. However, at a later stage, when formally booked out for his statement to be reduced to writing, he stated that he has consulted with his attorney, who told him not to say anything further. Applicant number 6, Sipakanyiswa Dladla, was arrested on the evening of the 26th of August 2021 at number 32 Victoria Street, Rosettenville. After his arrest, Sipakanyiswa Dladla made a point out and confession in respect of his involvement in the murder of the deceased. A J50 warrant of arrest was issued for Sipakanyiswa Dladla in respect of a murder and robbery that occurred on the 11th of May 2019 in Escort. He gave his address as number 32 Victoria Street, Rosettenville, an address he occupied for 3 weeks prior to his arrest. He comes from KwaZulu-Natal from an unknown address. Coming from KwaZulu-Natal, where there's no street name or number, referred to by the investigating officer as an unknown address. If those that come from those areas, being the applicants stated, are released on bail, possibilities are that they might not be able to be traced if they do not come back and appear before court. Interests of justice do not permit their release on bail. From the above, it is abundantly clear that the interests of justice do not permit the release of the applicants, that is 1 to 6 on bail. They all are linked to the charges preferred against them. Either murder, conspiracy to commit murder, possession of a licensed firearm, taking into account, of course, the doctrine of common purpose. Other than vehemently challenging the admissibility or not of the confessions and point outs made by the applicants. There's nothing exceptional that the applicants have placed before this court. Applicants have failed dismally so to prove on the balance or preponderance of probabilities that exceptional circumstances exist which in the interest of justice permit their release on bail. And in the circumstances, the following order is made. Applicants 1, 2, 3, 4, 5, and 6 application to be released on bail is dismissed. I thank you.
Your worship, we have on the date of the 24th of February for further investigation back to court number 23, 24 February 2022 and court number 23.
Ngoba nakho-ke ama-address awekho-ke